Hey everybody, I am JD Houvener and you've made it to the Bold Today show. We are live on Facebook, Google, and YouTube. Wherever you're joining us from, we welcome live questions. This is your chance to ask a patent attorney and, as you'll soon find out, a trademark attorney, any questions on your mind related to the process, the patent, the law subjects, questions you're worried about getting started. I'm the owner here at Bold Patents Law Firm, and it's going to be awesome to share this next half hour with you. If you missed us live and you're seeing this after the fact, you can join us live next week. We're here every Wednesday, 9 a.m. on the West Coast and noon at your lunch break on the East Coast. So join us there. And so for those of you that are joining us for the first time, I do want to let you know, while I am an attorney, unfortunately, this is not the place I'll be able to give you legal advice. So please keep those confidential questions, specific invention ideas to yourself. For now, don't share those here in this public forum. So I've got that disclaimer up for you there. But if you, after listening to the show or while we're talking, you think, you know what, I want to have a conversation. I think it's worth, taking a shot. We have got an opportunity for you to speak with one of our advisors and do a screening session to, see if the time is right for you to take that bold move, speak with one of our advisors, and then, yes, we'll reward you. We'll give you a copy of this book, Bold Ideas, The Inventor's Guide to Patents. It's a nice 150-page tutorial. Trust me, it's about an hour and a half read, nothing too deep, to get you in, what is invention all about? What is patents all about? So taking action, scheduling on that link will get you a copy. Okay, I want to introduce my partner in crime here, my future co-lead of this show, Matt Colsta. Matt, welcome to the show.
Hey, thanks, JD. Really excited to be here and share this audience with you.
Absolutely. Yeah, Matt, you've been part of our firm, I feel like multiple years, maybe 3 plus 4 years.
Yeah, that sounds
yeah, I mean, it's been wonderful. It's a great addition. Obviously, we're both patents. That's how we're kind of branding ourselves. But my goodness, it happens so often that inventors, entrepreneurs, every business owner, frankly, needs to think about their branding. And so it's come up so frequently that we've brought you onto the firm, and it's been awesome. We've had you on the show a few times, and this will be cool having you on the show going forward. So I'm excited to see, as questions come in related to trademarks, I'll be able to kind of take a step back, and let you answer those. So
happy to be of service to your clients.
Welcome. Awesome. Well, I'll have you hang in here. So no live questions yet, but keep an eye for me, would you, Matt? I'm going to be sharing my screen. The subject here today is going to be trade secrets. And when do they become patents, or do they? Okay, what are they all about? And I'm going to blast through a presentation with you all. So I'll share my screen here with you. And like I said, Matt, if you see any live questions pop up, let me know. And I will stop the yammering and get to those questions. So where are we? Yeah, I am infringing on my own copyright here. I'm reusing a deck I put together for San Diego Startup Week. No reason to reinvent the wheel. So this is all about to patent or not, right? When to protect innovations with patents, or when to keep them as trade secrets. And I think it covers the subject here really well. So let's jump right in. We're kind of limited time here, so I'm going to cruise. Patent law, okay, love it. It goes way back. The overall right, the fundamental thing happening with the patent is the government gives you this certificate, right, in exchange for, your investment of time and money and energy and learning about something, and you get to be the only one for 20 years that can practice it. So you exclude. It's an exclusionary right. You get to prevent anyone else from making it, using it, or selling it for up to 20 years. So the government rewards you for sharing your idea, helping us all become smarter. That's the overall premise, and it's actually written in the Constitution. I mean, these old farts thought about this for a long time. Right? They thought it was important enough to put right up front in Article 1, Section 8, to give exclusive rights to those inventors of those novel inventions. So that is part of the formation of this country. In large part, I think a lot of the motivation as to why we are hanging on as still the most innovative country in the world. So is what you've come up with patent eligible? The big question. And so it's got to fit into this bucket. I mean, there's a whole lot that is. And as long as it's come from your own mind, a creation, an invention, something you've conceived of human ingenuity, for the most part, it's eligible. Okay. But if it's actually more of a part of nature and you, in a way, sort of just stumbled on it and it found out an equation or law of nature or some sort of natural phenomena, that's not eligible. But I mean, everything else is. Machines, manufacturers, things you put together, compositions of matter, elements, molecules, and processes. So those are all eligible. You've probably heard about some of these languages, right? But what does it take to actually get through and get a patent? You've got to convince the examiner that it's novel, right? The first of its kind in the whole world, that it's not an obvious version of something else that's come before it. It does actually have to have some benefit. And that is a very low bar. Entertainment is a benefit. Okay, just an example. So one of the fun examples I like to give is there's a patent on a method for entertaining a cat with a red laser pen. That is a patent because it's patentable because it's some utility for an animal, entertainment purposes, right? So it's pretty low threshold. Different types of patents out there. Utility patents protect what something does. You got something that actually provides a real utility or benefit. There's also design patents. It doesn't actually have to have a utility as long as it has a unique shape. So common design patents, for wheels, right? You see a lot of different rims and designs for different types of covers. And then there's plant designs, plant patents rather, where you actually, if you've been able to grow through grafting or other scientific chemical ways a new strain of plant that's reproducible, that is also patentable. Lots of changes in the law of the past year. Won't dive into these too much, but the big one is first to file. So don't wait. Get with your patent attorney, work up, do the search, get your patent filed. Don't wait around thinking, oh, just because I've invented it and written it down in my journal, I'll be able to claim it as mine. Nah, it's not the way it works anymore. This law changed in 2012, and now it's the first to file. So they want no reason to sit on your laurels. Okay, so timing considerations. Use NDAs. Don't just share your invention publicly. Know that you're on a timer. The U.S. has given a grace period of up to a year to file your patent application if it did go public. But if it's been more than a year, you're out of luck. All right, you can make a lot of money with patents, and these are the ways to do it. I'm kind of speeding through this presentation just to make sure we can hit the major points. Okay, let's talk about trade secrets. Now, we talk patents, you got a real quick primer on patent law. Trade secrets, what are they? There's no certificate, okay, given for a trade secret. It's just you have the ability to enforce it. And it is when you have something that's valuable, information that's valuable. It's really what it is. And for it to have value, it can't be part of the public knowledge. That's really it. It doesn't mean that no one else knows about it. It's just not part of the public knowledge. And you're making efforts to keep it secret. So keeping it in a vault, putting digital protection over it, access, passwords, those are all fairly good, reasonable protections to keep information secret. Usually it requires you to have some sort of company or have employees or individual people that have access to this information. So this is the big 3 bullets on whether you have a trade secret or not. And again, this doesn't have to be as big as the secret to your recipe. This can be simply a customer list. Sales script is trade secret. If the public doesn't know about it and the way you're going about that process is unique and it provides you that benefit over your competitors, it's likely a trade secret. And so you want to identify it as such and label it as proprietary or trade secret right there on the document, whether it's physical or digital. So, what can they be? I gave you an example of that: customer data, business process, manufacturing methods, formulas, and certainly software. All right, so when do they get discussed? All the time. Employment agreements are the number one, okay? And there definitely is crossover between intellectual property and employment law when it comes to trade secrets. When you sign on as an employee somewhere, if you ever have done that, you likely have already agreed to assigning or giving up ownership of any intellectual property that you develop while on the job. But it's also part of that, anything you gain access to, right? For proprietary, secret information, you are supposed to keep it there. You're not allowed to disclose it outside the company. And then on exit interviews, upon leaving the company, you're reminded of that, usually in the form of a severance package. Here's your, 4, 5, 10 grand. But by the way, you are re-signing and acknowledging the fact that you can't take this information and go give it to a competitor or start your own company. And that happens a lot. In fact, it happens with the big guys. And it did here with Google and Waymo, the self-driving cars. And this huge, engineer, very knowledgeable in the space, was with Uber, left the company, and months later started his own little company that was bought out by Waymo, right? So he actually downloaded thousands of documents from Uber, and it was very easily traceable, didn't really think about what he was doing. And so without that monitoring, without Uber having that software in place to see that he had taken misappropriated information, trade secrets from Uber, and in a way subverted that over to Waymo, they wouldn't have known about it. And so trade secrets, even though there's no patent, there's no certificate, about that, what that information is, they were able to get a multi-$100 million settlement because of that employee that did take those trade secrets. So there's ways to enforce trade secrets. They are powerful. And so that's the number one way to make money with them is by enforcing it, right? Keeping that secret information within your company if it's worth keeping, okay? And so if you do it successfully, you can keep it, have a competitive advantage well beyond the 20 years that patents provide because trade secrets don't have a limit, right? As long as they remain a secret, you're keeping it secret, and it has that initial value, you can have that benefit for as long as it's there, right? Think about KFC or Coca-Cola, some of these really famous recipes that have lasted generations. Okay, so here's a big test here I wanted to get to, given that backstory, all right? So the Ripoff Test, this is the biggest one. I always mention this, whether I should keep it as a trade secret or keep it as a patent. So the question is it reverse engineerable? If you were to make this product and sell it on the open market, would your smartest competitor be able to buy it, take it apart, tinker with it, and figure out, that's how they did it? And if the answer is yes, or even maybe, you would probably want to pursue patent protection. Patents are going to give you that ability to prevent that competitor from being able to make and use and sell it, even if they reverse engineer it. They'll have to figure out a new way to skin that cat. But if there really is no way, you think hard, and there's no way they could figure that out, either through the fact that this can't be done, even if they break it down chemically, boil it, break it apart, there's just no way. You might be able to keep it as a trade secret. And one of the cool examples I like to give is in the aerospace industry. A company like Boeing, they've got a lot of trade secrets around their manufacturing process, right? The actual method of how they produce parts or carbon fiber, for example. And that exact method of the layup, how long things are in the heat or how long they get, how much adhesive they get, the different layering and the packaging and how it's formed, that's not patented because it's not going to be able to be discovered after the fact. It's not reverse engineerable. All right, so factors to consider. Sometimes it's worthwhile keeping inventions in-house, right? And waiting for the right timing of the market. There's a lot of inventions that we work on that are patented, and they're ahead of their time, years ahead of their time. The market really isn't there yet. There's no demand for it. And the risk is, okay, well, will there eventually be demand? And we're just sort of waiting for either customers to want it or companies to sort of surface and start to infringe, and there's evidence of use there. Of course, the big risk of holding on to an idea, and one of the big incentives of the patent world of why they want the first to file law in place is they don't want people waiting, and they want there to be a risk of someone else inventing it and going after their patent. Because as soon as someone else files a patent on your secret, it's lost its trade secret value. It's part of the public knowledge now. So you take that risk that someone else, some other company, some individual is going to develop it and bring it to the public while you still kept it as a secret. Okay, and that's this investment, right? Do you invest in a patent? Do you want to go public with it or not? There is an additional consideration here. There are some ways to publish information without getting a patent. And some companies, IBM is really famous for this, where they'll actually issue defensive publications. And they don't plan to monetize whatever they've invented. They just stumble on it in their R&D, and they just don't want their competitors to get a patent on it. They can publish it, publish their findings, publish the invention in a journal, a well-known journal across the industry, so that the competitors are not able to get a patent on it because it isn't new, right? Whatever they've come up with has already been published by IBM. So a defensive strategy is definitely part of the equation, usually reserved for those kind of on the upper echelon that can afford to, in a way, just generate content, information, inventions without the true intent of commercializing them. All right, and the last one here is that if you have a trade secret and you've kept it sort of in R&D and you're in the waiting, if it's part of your product, if it's going to be sold by you, that would start a clock, a 1-year public clock. And if more than 1 year goes by, you would be ineligible to file a patent on that. It would be invalidated. So if you can truly keep it secret, and if it's not part of your current product line, it's possible to keep it as a trade secret. But really, the way the laws are set up now, you're incentivized to just file that patent. All right. Licensability, patents for trade secrets. I mean, patents, obviously there is a four corners legal document. The claims are there or the drawings are there. And, of course, they're debatable in terms of their definitions, but it's written in black and white. Trade secrets, there's a lot more gray, right? What is the secret? What is contained there? So whenever you're trying to license or negotiate, contract away what the asset is, always going to be more clear with a patent versus a trade secret. So that's the presentation there in a huge whirlwind. But hopefully you guys are able to check that out and get that digested. I see we have a couple of viewers there. Awesome. So it looks like we're going to be moving to our next segment. And it's like Facebook, there was an issue on publishing there on Facebook. Let me try to fix that. Okay. Okay, well, we're still publishing on LinkedIn and Google. Well, bummer. There we go. All right, Matt, so thank you for hanging in. What I want to do is go to our avo.com questions, and I've looked at those before the show. There was only trademark questions, so you're going to be loaded up. This first one here, this first one here is coming out of Seattle, which is where I went to school and kind of my old stomping grounds. And I'm just going to put this question in here and see where it goes. So you'll see it on the comments. And I'll pull it up on the screen so everybody can look at it with us.
Sounds good.
And before we jump, if anybody watched that previous segment, and if you have any questions, feel free to pop those in. I will get back to those as well. So don't feel like you've missed your window to ask questions. We'll be here for another 15 or so minutes. All right. So is Empire Trucking already a trademark? I plan to make a truck club, which I don't know, that's awesome, and would like to call it Empire Trucking. I would like to register it to the trademark, but I'm not sure if it is already. So what are your thoughts on that?
Yeah.
Obviously, you don't have to, go ahead.
Yeah, interesting, right? So when I think of, trucking services, right, I'm thinking of typically transportation services. So this particular individual is asking more about social club services, it seems like. So at the United States Patent and Trademark Office, there are 45 classes of goods and services, everything from apparel to legal services, like you and I provide, JD, to social club services falls into one of these 45 classes. So what the potential client is really asking is that, can we potentially register Empire Trucking in International Class 41, which is education and entertainment services, and social club services fall into that category as well. So if we were to dig in and do a little bit of research on this, what we would be doing is searching the United States Patent and Trademark Office's database of registered and pending trademarks, and specifically looking at International Class 41 for anything using the word empire or emperor, or anything similar to that, dynasty potentially, anything that could potentially be similar in sight, sound, or meaning to the word empire. And that's where we'd be looking to see if we can register Empire Trucking as a social club service.
Cool. So
yeah.
let's just say that you do the search and there's really no conflict. Is it feasible then to say that there could be an Empire Trucking, which is the trucking we think of, moving freight, down the road? They could coexist with Empire Trucking, the social truck club. Is it true?
Yeah. Absolutely, right? So logistics services are going to be in a totally different class than social club services, right? So yeah, the likelihood that those two could be confused with one another is very limited because they travel in different channels of commerce, right? People who are interested in logistics services typically are not looking for a truck community in terms of what I'm thinking is, which is going to be probably like a community of folks who are interested in building trucks and doing that sort of thing. So yeah,
awesome,
different.
All
so
right.
Yeah, theoretically, yes, registerable if it's not registered in 41 already.
Thank you, Matt. That's awesome. Very good answer there. This is a question from Spartansburg, South Carolina. I love how we get these from all over the place. Little mix up between copyright and trademark, but let's tee the question up. So how can I find out if a tribal symbol is copyrighted? They may mean trademark. I found a tribal symbol that I thought looked great, and maybe I could use it as a logo, but I don't know if it's copyrighted and don't want to get sued.
Yeah, another really, really good question. So there certainly is an intersection between copyrights and trademarks. Obviously, trademarks are going to be used on products and services, and they're going to help connect your potential consumer to your product and service through that design. Whereas a copyright is going to protect the artistic work of that design itself. And so you could potentially be in violation of a trademark and a copyright from the same use.
Got it. Double whammy. Okay.
Double whammy. But in terms of registering something like that, what we do at Bold IP is we're going to take that that design, that tribal image that you're interested in registering, and we're going to balance it against reverse Google search images to see if it's been used anywhere else online, not registered. And then the USPTO, from a trademark perspective, makes it very very easy for us to kind of take that symbol apart and search it by design elements at the USPTO in terms of what's registered. So we would break that logo down into multiple different aspects, potentially like geometric designs. If there's animals involved, there's specific codes for animals at the USPTO, and we'll search those specific design codes at the USPTO to see if there's anything else that's been registered that's similar.
Cool. I didn't know that about breaking up the design of a logo. That's new for me. Cool.
It's very interesting. The USPTO has a design basically manual. And if you ever just want to kill 10 minutes of time and just see how granular it gets, it's actually pretty fascinating.
Cool. All right. Well, let's get to this. I want to try to get as many as we can. Probably another 2 or 3. This is out of New York, and it's about protecting words.
Sure.
Again, any live questions, we'll take those right away. So keep those coming if you're watching. Okay, so here it is. Protecting words. Is it possible to protect all iterations of a word if a company name is made of 2 words, but one is trademarked in the same category? As you would be infringing to use both words together, or putting them together, do they become a new word?
Oh, interesting. Okay, yes. So good question. So I think what the viewer is asking is basically, if you have a trademark that's 2 words, and one of those words is already registered for similar services or products at the USPTO, am I in violation of that trademark? And like any good attorney, the answer is it depends. So here's what I would say about that. Now, if both of those words in your proposed trademark are suggestive of your product and service and not descriptive of it, there's a good chance that you can get around that prior registration with your highly suggestive 2-word trademark. Now, if the USPTO could just view your new trademark as a derivative trademark from the prior registered trademark, that's going to be a problem. Likewise, if that second word that's new to your trademark is descriptive of the services, say you're in construction and you call yourself, Crooked Nail Construction, or something like that, that word construction is just descriptive, and the USPTO crosses it off, in which case you're going to be in violation of that prior registration. So. Got it. Yeah. Got it.
So it kind of comes down to, is it going to be a derivative? Is it going to, to a consumer, will it be similar enough when you combine them in a way?
Yeah, and there's a sophisticated process the USPTO goes through to see if those 2 trademark applications and registrations present what's called a likelihood of confusion. But your trademark attorney will kind of walk you through that process when they do their legal analysis.
Awesome. Matt, you're amazing. These are great. Okay, we'll do a couple more. This has got a good example in here. All right. So can I use a trademark word as part of my company name? I have been contacted by a company who would like to have 3% of my revenue for using 1 word of my company name, but my company name is in 2 words. Is it possible to protect all iterations of a word? The word is Waldorf, so they're telling us what the word is. Many thanks.
Yeah. I would need to see it before I would advise a client if they are required to do a licensing agreement. I've seen this type of behavior from third parties before, where they're asking you to pay 3%, 10% as a licensing fee. And more often than not, there is no valid reason for you to enter in some sort of licensing agreement for the use of that word. If in reality they're legitimately using that trademark and they have a problem with it, they're not going to ask you to license it. They're going to ask you to cease and desist. So I would be very hesitant to sign that agreement.
Excellent. At least I get a legal opinion on it for sure. So you're saying
Correct.
Yeah, but by them sort of being so bold and brash to do it, they're saying, one, you're infringing, and here's our offer.
Right.
There's a lot of assumptions. It's pretty aggressive, and don't get bamboozled. Basically,
Right.
Get with one of your attorneys. Yeah.
Like not, they're sending that same cease and desist letter or licensing agreement letter to hundreds of other folks.
Okay. Very good. This is similar to a previous question we had. This is out of Billings, Montana, and it was asked just a couple of days ago. Yeah, I think it has clothing related. So here we go. Can I use a trademark name that is a completely different industry? I'm starting a veteran athletic clothing brand, and I want to use a name that's trademarked by a company that specializes in global finance equity and venture capital consulting. Good to go for the most part?
I mean, in theory, yeah. And to the viewer, thanks for your service. Yes, absolutely. So when we talk about finance, real estate, those are all going to be in international class 36, which is a completely different class than the apparel class, which is 25. So there is historically no likelihood of confusion between those two classes, 25 and 36. There's no reason that a registration in 36 would block your application in 25. Of course, you should still talk to an attorney about it because international class 25 for apparel is very similar to the jewelry class. So you're going to want to make sure that you search both the jewelry class as well as the apparel class whenever you're doing an apparel application.
It is impressive you have these memorized, Matt, the different classes. You've done this long enough.
All of it for the last 10 years is trademark law.
Awesome. Okay, this one kind of approaches copyright too. And I like the artist of this music. So Bob Dylan song. So they want to reserve a perfect brand name. They've got this. This is the one. Comes from lyrics from a Bob Dylan song. Can't believe anyone's already reserved it. Any issues to think about here with respect to songs and using it as your brand?
I mean, I would say generally not. Okay. As long as you're pulling a single, couple word lyric out of a Bob Dylan song, who's from my home state. Obviously, I'm from Minnesota, and that's where I live today. Robert Zimmerman from up north. It shouldn't be a problem. Now, if you're using a title of an album, Blood on the Tracks, Blonde on Blonde, I mean, that's going to be a problem for Bob Dylan's intellectual property attorneys. But in theory, if you're, calling your band, Girl from North Country, or you should be okay. Now, Mr. Tambourine Man, probably not. That's
probably not. Yeah. Okay, got it. Use your best judgment. I like that. So if it's a title track, album cover, something well known, like okay, you'd be maybe in trouble there. We got a live question from Sam P. Watching on YouTube. Can I use the trademark symbol? I'll pull it up here for my inventions on my products or not? Please. Thanks. I'm in Johannesburg. Thanks for your question. So can I use the TM symbol for my inventions? Okay, well, and I advise this. I'll jump in real quickly. You correct me if I'm wrong, Matt, but when people are using or they plan to use, word marks, logos for what they will eventually seek registration for, I advise them to put the TM, right? Sort of acknowledging, letting people, any third parties know that they intend to use that mark to indicate the source of their goods or products. And certainly you can and should use that before registration. That's what I advise people. Does that sound about right?
Yeah, 100% right. That TM symbol just means that you believe you have unregistered trademark rights in that name or design for that product and service. Whereas the registered trademark symbol, the circle with the R on the inside, means that you actually have a registered trademark at the USPTO.
Yep. Actually, on this broadcast on the upper right, I've got bold patents with the TM. I think we may have registration now. Is that right? Or we're working on it?
I think we might now at this point.
Okay. Let's update that to circle or follow our own advice. Excellent. And I will just a quick note, Sam, say, be very careful with respect to sharing your invention before filing. You want to make sure you're covering yourself, working only with very close circles with a non-disclosure agreement if possible. So if you haven't yet filed, work with a patent attorney and get that filed first before sharing it publicly. Guys, we're right at the end of the show. Thank you for that live question, Sam, and keep those coming. If you missed us live, we're again here Wednesday, 9 o'clock on the West Coast and noon on the East Coast. Matt, thank you so much for being a part of this going forward. This has been great. And we'll see you all next week. Go big, go bold.